Make sure that they're not here. All right, folks, let's see. We have Ty Presley, Anthony Cancel, Deborah Randall, and Wasim Q. I just want to make sure that folks are in the right courtroom if they're here for a matter or if they're just here to observe. So, Mr. Presley. All right, let's move on. Mr. Cancel. Ty Presley, just observing. Okay, very good. Want to make sure that sometimes folks show up in the courtroom and then they find out they're supposed to be in another courtroom if they have another matter. So, Mr. Cancel, you're just here to observe as well. I think you said something. I don't know if he did or not. All right. Well, okay, very good. And Ms. Randall? Anthony Cancel, yes. Okay, good. Ms. Randall? Just observing, very good. And Wasim Q?
Just observing.
All right, thank you very much. I just wanted to make sure that people didn't have business in front of the court. Maybe we're in the wrong place, but okay, very good. We'll get started then in just a few minutes as soon as Mr. Tosic comes back on. All right. Mr. Tosic, we'll get started here in just a second. I have a couple of orders on some other cases that I'm signing, and then we'll get started.
Thank you, Your Honor.
You're welcome. Okay, there's those, and we can go ahead and get on the record. All right, next matter is State of Washington versus Predrag Tosic, 223-0199-32. Can you introduce yourselves for the record, please?
Thank you. Brian Case representing the state.
Oops, I need to put my video on. Sorry about that. All right, and Mr. Tosic, you're present here by Zoom. Can you hear us? Okay, there we go.
Predrag Tosic, a living man, sui juris / pro se.
Okay, and a couple of matters that I wanted to take up. before we get too far along here that may have some impact on how we proceed. First of all, I had anticipated doing three matters, three issues, I guess. One was to make sure that we got a court order. Mr. Tosic had mentioned before, and we had talked about the fact that there had not been an order that I had signed from a motion quite some time ago. This was on the dismissal for lack of jurisdiction. You had prepared a ruling, sent it to Mr. Tosic. Mr. Tosic didn't respond. I think last time we were in court, he indicated that he understood that I was going to sign this one. I've made a couple of changes to it. The only changes I made, Mr. Tosic, can you see okay?
Yes.
Okay. So hopefully,
Well, okay. Not.
you'll see here that I wrote findings and conclusions of law. And,
Yes,
and I'll send a copy of this to you. But
Okay, please.
on this page, I crossed out the word conclusion and I wrote order. And then when it says the court held, I put the court rules and then what the ruling is. And I'll send you a copy of this. So I've signed this one. So this, I believe, will allow you then to go forward with a revision if you choose to do that on that particular matter.
Okay, so I just have one question, Your Honor. Obviously, I'll read when I get a PDF. I mean, I could just see the basic handwritten things, but it's impossible to read everything in detail. I did include my objections. Mr. Case followed the procedure, but then so did I, in terms of, now understand that the written ruling is the final official ruling, but I think it was appropriate that they say, hey, yes, the commissioner denied my challenge to jurisdiction. However, the commissioner did not say X, Y, Z off the top of my head. And so have you reviewed my objections prior to?
I have. And the way that would then be handled is that if you believe that this ruling that I'm signing here, if you believe that it should include additional information or you believe that there is some other basis for it, then that's what the revision would do. You know what I mean?
No, I do, but there was also the previous step, which is, and I do have an issue, but I understand that all Washington state courts do it that way. I think it's a bad policy. But the prevailing party drafts, the losing party on a particular motion objects, not in terms of whether I agree with the ruling, and we discussed that, and you clarified it, and I said that I'm clear on that part, at least I believe I am. I'm not arguing with you further, rather I'm challenging what was stated, including what the oral ruling, my knowledge, was.
Totally understood. And that would be the purpose of a revision if you believe one is necessary. So once you get this and you read this, if you believe that your objections should have included something, or if you believe that this should have included something from the objections, then that would be the purpose of the revision as well.
Okay, thank you.
Okay.
I just, Commissioner, if I may, just one more sentence, because of my super important deadlines with appellate courts, I'm aware the standard rule for revision, I believe, is 10 days.
Mm-hmm.
I'm asking that I be given till like June 20th or 21st, which isn't too far out, but it allows me to focus on super important deadlines next week with regards to, and then I'll either file for revision or let it go insofar as this court and this particular matter. But I'm just asking for like a extra 6 or 7 days.
I wish I had the authority to do that. I don't have the authority to make that particular change at this particular moment, and I'll explain the reason why. One, there are a number of court rules that contain that, and RCWs as well that contain that, and I don't have the ability to alter that necessarily. That's not a decision that's left up to the discretion of this particular court. In addition to that, if this goes to another judge or goes to a judge for the revision, they would have to make the ruling on that. So what I usually tell people is to stick to the 10 days, file the notice of revision, and then also let the judge know that there may be some amended pleadings coming if you can give some more time to do that. That's one of the things that I suggest to people.
Okay, thank you. And who is the judge? I mean, Ms. Kelly told me, or Kelly, but it's better that I just ask you to make sure.
So I don't know who these go out to what are called IC judges. What that means is that they are, I think IC stands for individual calendaring. I'm not sure. But what it means is that there's a certain number of judges that handle unassigned matters. And so I don't know who it would be at this point. Ms. Callan would probably be able to tell you that. Okay. All right. So the next matter then are the two matters that I was anticipating for today would be the underlying motion for contempt and Mr. Tosic's May 15th motion to vacate. Is that your understanding? Hey, hang on just a second, Ms. Tosic. I know you might disagree with that or not be aware of that. So, Mr. Case, is that your understanding?
The motion for a contempt hearing was waiting for this ruling to be signed.
Okay.
My understanding is we were going to deal with his order to compel and the order to vacate today.
If I may, Your Honor?
Yes.
Don't mean to talk over Mr. Case, but he seems to be done. That was my understanding too. In particular, jurisdiction needs to be resolved first before the merits can proceed. And then, as I pointed out, I believe either on February 27th or on the March hearing, there needs to be time for discovery, assuming this case is not dismissed. With regards to the two motions I brought up, Your Honor, that is true. Mr. Case summarized it correctly. This is what I brought up.
Okay.
I stepped back and basically motion to compel is specifically related to this matter. It's not a collateral attack or what have you. As such, it may imply that I'm granting this court, the jurisdiction I've been challenging, right or wrong. I've been challenging that jurisdiction. You're aware of that. Mr. Case is aware of that. So perhaps motion to compel, which will also expand, adding more questions, should wait until discretion is fully resolved, for the lack of a better term. And again, I speak as a pro se, but you understand what I mean by that. Now, insofar as the other request, again, I'm not wasting court's time because I'm asking the court to dismiss on different grounds from previously. And then I'm also, to use Mr. Case's actually own term from one of the prior hearings, and I mean, I did do a little bit of research on that, I'm making a collateral attack on one particular thing that the state is trying to enforce or find me in contempt of, which is, and again, I'm not expecting that you can read the details, but which is the November 2018 hearing specifically ordering childcare costs. And for this, I provided evidence that was fraud. The state knew it or should have known it, not based on the letter from 2023, obviously, but from what I brought to the Division of Child Support and subsequently Office of Administrative Hearings with regards to the nature of that childcare. My understanding is, and I'm not asking the court for legal advice, that motion to compel to answer interrogatories, which again, I'll expand assuming this court is established by an IC judge to have jurisdiction. I think that should wait, but it's perfectly appropriate to say, look, this court has the authority to vacate orders that they claim are null and void by a lower court, administrative court, and the orders are null and void because they're based on fraud, because the child care part that was added to child support is based on fraudulent child care. I know that this court doesn't deal with child care. However, it was the DCS and the Office of Administrative Hearing and ultimately the state who made child care expenses a part of the child support. Yeah. And so there are three orders, and I'm saying that this one of the three, can be vacated today without me yielding on jurisdiction, because if you will, it's a collateral attack on a fraudulent, I'm not saying that the Office of Administrative Hearing committed fraud. I'm saying that they made a ruling based on fraudulent presentations.
I understand.
Child.
Okay. So that and that actually brings up the other issue that I was going to mention, and that is that I have to be sure that I get on the record that there were 3 emails that you sent me, and which I understand, but I wanted to make sure that the record is clear that you sent those to me so that it's not considered ex parte communication. So I'm going to read those just real quickly into the record. They're not terribly long. So this one came in on Friday, which would have been, what was the date on Friday? The 2nd.
June 2nd.
Okay, so it says, Commissioner Rugel, I pray you won't find this to be an abuse of your email you kindly shared at the previous hearing. I am reaching out for two specific reasons. One, to make sure you received previous documents in the email below, and I sent you one other email also on May 15th. And the one on May 15th was the one that we had discussed on the record that he would send me the documents that had not yet been filed or hadn't made it to the file.
That is correct. There were two emails total on May 15th.
Yeah. So I wanted to make, so that's what he's referencing there in this email. Two, to notify you on the following, your court being an open court and Monday, June 5th, hearing being the first, while I'm explicitly going to demonstrate with the prima facie evidence that at least one part of so-called child support in the state is after me for the part pertaining to claim child care, which is what we're talking about here, back in 2018, 2019, which has been added onto my child support base per information from ex-wife and her best friend is outright fraud, and that so-called DCS and by extension the state are complicit in the said fraud. That I intend to invite some court watchers join the hearing around 8:45 PST or shortly thereafter. And I think that we have them all on the line on the Zoom call now. I kindly request that court watchers be allowed into the Zoom call. Muting their audio and disallowing their video is perfectly fine to not disrupt court proceedings, of course. In open court means I, as a sui juris party, am entitled to have observer witnesses and watchers over the court's proceeding attend those proceedings via Zoom or in person. Respectfully, Predrag Tosic, a living man, target of political persecution by the state and its agencies, also victim of DV and other abuse for years, which this state and its family courts have ignored, indeed rewarded, in order to ensure continuation of racketeering, aka child support stream of income. Okay, so that was one of the emails, and I just wanted, the other two are also pretty quick. So I want one of them we just got this morning. Two this morning, I think. So the first one, and this one I think is more pertinent to what we are currently discussing, and it's important that, Mr. Case, that you understand this as well. This one indicates regarding Washington Spokane County Superior Court cause number 22301-98932, corrected notice for calendar and new motion to dismiss or vacate due to state's lack of compelling interest and fraud. The latter to be addressed in federal court. Amended motion to dismiss due to lack of compelling state interest and motion to vacate OAH order from November 2018 is null and void based on fraudulent misrepresentation regarding childcare expenses. Also, minimally revised declaration from May 15th regarding specifics of childcare turned child support fraud from 2018. I understand these two submissions, while based on documents filed or served on May 15th, are obviously submitted very late. The June 5 hearing. If Honorable Commissioner Rugel and or opposing counsel, Mr. Case, need continuance, that's of course fine with me. I've been dealing with multiple courts concurrently while coping with major trauma caused to me by years of abuse at the hands of narcissistic, abusive, coercively controlling ex-wife. The so-called family courts in this state, DCS Mafia and their enforcers, and the state of Washington. I'm acting in good faith and not trying to delay anything. It's not in my interest anyhow. Before my motion to compel is to be heard, both jurisdiction and current motion to dismiss due to lack of compelling interest.
You have those documents in the car?
Yes, I do.
Okay.
You want them back?
I'm going to mute them. Okay. I muted the amicus curiae person. All right. Jurisdiction and, where was I? Need to be resolved first. That was at 7:33 a.m. that I got that one. Okay, so put a pin in that one. We'll come right back. 9:06 a.m. I am respectfully this is to the court from Mr. Tosic. And I think that Mr. Case may have been CC'd on this one, but I just wanted to make sure that this is in the record as well. I'm respectfully requesting a standby attorney moving forward for future hearings on this matter, assuming the matter isn't dismissed later today, obviously. I understand it's too late for today's 10 a.m. PST hearing, but assuming the matter of State versus Predrag Tosic isn't dismissed per my motion from May 15th, an amended version of it from earlier this morning, since the next hearing, if any, is going to be at least a week away. And given what Commissioner Rugel stated regarding my rights to representation, as well as my insistence on, one, not granting the court jurisdiction, not of my own volition anyhow, and two, retaining the ability to speak to the court myself, I believe it's fair and appropriate to have a standby attorney present at all future hearings if the case does not get dismissed per my May 15th motion. Okay, so those are the three emails that I got. I know that you got the last one that I read. Did you get the one from 7:33 this morning? It looks like you did.
Yes, I did.
Okay, so I just wanted to make sure that everybody had the same information. So,
I had a couple of matters I'd like to discuss before we start, if that's. okay.
Yeah.
Or-
sure.
so,
Well, it may not be. Let me think for a second. Here's why. The underlying issue here is the contempt. That's essentially how this court is most primarily involved, at least. And Mr. Tosic is seeking to have his issues regarding the court's jurisdiction and otherwise have those resolved prior to hearing the actual motion for contempt. But obviously, they're all intertwined. They all kind of involve each other. Mr. Tosic is asking for a standby attorney with the caveat that he wants it understood that he's not submitting to the jurisdiction of the court by doing so, and I understand that. And he's asking for that standby attorney primarily for the contempt motion that would be heard after today. The issue.
I apologize. Yes.
No, go ahead. What's that?
For that and anything else that I may
Right.
bring up, such as, a motion to compel the DCS,
Understood.
the instant interrogatories. And so, yes.
Understood. So the difficulty there is that because he is entitled to an attorney and up to this point has refused to accept an attorney, even a standby attorney, and understanding that I have emphasized the importance of having at least a standby attorney present for him, I'm a little bit of a crossroads here as to whether or not I should appoint the standby attorney now, since all of these things are related to the contempt. And what I'm concerned about is that if we don't do that, that we may run into an appeal issue. If we don't. In addition to that, he has a right to have an attorney. Even if it's a standby attorney, he has that right. And I'm not interested in taking that right away from him. It may also ease some of the communication, or maybe won't. I don't know. He's not giving up the right, as he indicated. At this point, at least, he is not giving up the right to address the court directly, which I understand. And so that's the first issue that I want to resolve before you bring up anything else, if that pertains to it.
It does directly. I wanted
Okay.
to speak about the pro se representation
Okay.
and his behavior up to this time in court. And I understand what the court is saying, that if he's now asking for assistance, we would suggest that he do what everyone else does and come down here to pretrial services and apply for public defender.
Okay. So, Mr. Tosic, so what I'd like to do is this. You've made a request in a very specific way to have standby counsel. And I believe that I understand what your request very much is, and that is to have standby counsel to retain the right to address the court directly. And in asking for standby counsel and having standby counsel appointed, that you are not submitting yourself to the jurisdiction of the court.
It's fundamentally correct. I would just like to add one point. You did
Okay.
offer Commissioner Rugel legal representation, including free legal representation, whether on February 27th hearing or one of the prior hearings. I was not aware that the standby option was offered. I recently received some limited advice from people way more knowledgeable than me, and it sounded like it's a very good idea. again, while preserving the
Mhm.
rights as a sui juris that you just mentioned. And those rights are important to me. I'm not going to comment on Mr. Casey's comments about my behavior in court. I don't think there is anything wrong with it. I think it's First Amendment protected, and per New York Times versus Sullivan and other Scottish case law, sometimes things get emotional and fiery. And in a democratic society, debate should be allowed, including the government and its different branches hearing things they don't enjoy hearing. And I'm going to limit my editorial comments just in order to use your time and everybody else's efficiently. I think I've made some progress in that regard. But whether Mr. Case or DCS likes certain allegations, I stand behind them, and I have every right per First Amendment and the rest of the Bill of Rights to say things Mr. Case or the state or his bosses or DCS bureaucrats don't like to hear. Unlike the state, I will add one more comment, Your Honor, whether it's this court with regards to this matter so far, with regards to the domestic violence matter in 2019, 2020, as well as other state courts, nobody, including Mr. Case, will find, maybe they'll find inappropriate language, nobody will find a single instance of lying to the courts, a single instance of my perjury. In contrast, ex-wife, with whom the state has sided, de facto sided against me, has committed so many perjuries, she should be in jail for a few years, and the courts have invariably, including Spokane County Superior Court in the domestic violence matter, looked the other way. Furthermore, the state has committed basically perjury. Whether Mr. Case is aware of certain things or not, he should know, even if he doesn't. One of those matters I think it's appropriate to hear today, because again, it's a collateral attack on the November 2018 administrative court ruling. And I will quote the old Latin maxim, which may not be categorically controlling, but which is a principle in English common law, which is falsum in uno, falsum omnibus. Excuse my poor pronunciation. I'm neither a medical doctor nor a lawyer. Today, once we get to that point, that is my collateral attack, if you will, it will be established, I argue, beyond any doubt that the state lied. The state may not have had my letter or the DCYF letter from January 2023. I have tried to bring the state's attention in 2018. This woman is not a child care provider. She doesn't have a legitimate business. She's not licensed. The agreement in parenting, the agreement at the mediation in which the first parenting plan was based on the other parent and her attorney knowingly misleading, lying in the mediation that Heather Blakemore Thomason's best friend is licensed and has a legitimate child care business in Bothell, Washington. The DCYF letters prove that not to be the case. But even in late 2018, I raised this with the DCS and the Office of Administrative Hearings, and I was ignored. The state is the one who should be ashamed for its behavior, not me, whose health has been ruined, whose life has been damaged, whose career has been ruined, and whose child is kept away from me so that the state can engage in racketeering. Thank you, sir.
All right, thank you. So what I'm, hi.
Go ahead.
Go ahead.
First, Your Honor, just on the matters that Mr. Tosic wants to talk about today. We have not been properly served. The emails that we get do not have a filed stamp on them. So as far as we know, they've never been filed with the court. I know that he emails them to Ms. Peterson. She does not file emails. He has to file his own documents, and they have to be served properly. So the other thing is he can't ask for an attorney right now and then say we're going to proceed with these matters, which is what the court, I think, just said.
I understand.
It's once again back 3 months where he wants it both ways. He wants to say you don't have jurisdiction, but then wants you to hear the matter.
So what I'm going to do is I'm going to appoint an attorney for Mr. Tosic. It'll be under the circumstances that he's agreed. That I don't necessarily have a problem with that. How does he find out what he needs to do next in order to make that happen? What does he do? I don't know. I just don't know the logistics of how he gets an attorney. I just need. I don't know if you know. I have no idea.
Your Honor, if I may.
He just goes to pretrial services and tells them he needs to apply for a public defender, and they will give him the forms. He'll fill them out, and if what he's been telling us is true, then they'll appoint him a public defender.
Okay. And apparently there's some forms to fill out. That's the best that I can get for that. So,
Your Honor, may I reply to the last comment by Mr. Case and also his previous comments? I'll be brief and to the point.
you mean about if what he says is true, that part?
Well, it's not true that I've been seeking both ways, as he said, and I made that clear.
No.
I think this court is aware of that. With regards to what I'm bringing up, again, it was Mr. Case who educated this court and myself about so-called collateral attacks. So I think that's perfectly appropriate without granting either subject matter or personal jurisdiction in a matter of State of Washington versus Predrag Tosic. Again, I'm seeking for the case to be dismissed entirely because there's no compelling interest. Racketeering
I understand.
under the color of law is not, but I'm also attacking a particular ruling, one of the three that the state claims I'm in contempt of. And that ruling is based on fraud. So Office of Administrative Hearings was a little deaf to the arguments back in 2018. Presumably, administrative courts can allow hearsay and so forth and choose who to believe almost arbitrarily and what have you. I have evidence that the child care was fraudulent. And so it's perfectly legitimate. And the last comment is I'm not seeking a public defender in the traditional sense. And this was discussed already. I'm specifically looking for standby.
Understood.
Once amicus curiae clarified for me what standby is and so forth. And so I'm very specific in what I'm asking.
Yes. And what I can tell you is that those were Mr. Case's words because I asked him how it is that you go about to get that person. So once a person is appointed, my understanding again is that he is being appointed as standby counsel, that you retain the right to address the court specifically, and that he would be appointed for the purposes of representing you for matters relating to the contempt. And as I said, all of these matters seem to have contempt as the underlying issue. So I would take into account a number of different things. So who can give me more hard and fast information about where is pretrial services? How does he get there? Where is it at? Address, anything like that?
Pretrial services on the ground floor of the annex, right
Okay.
behind us here.
Do you know where the annex is, sir? It's
I
11.
believe so. I'll find it.
He could ask any security personnel where pretrial services are
Okay.
built.
It's here at the courthouse, but it's kind of like the newer part of the courthouse in between here and the public safety building.
I'll find it.
It's a little chunk of a building.
Oh, and Your Honor, just one more quick comment. I apologize with regards to what Mr. Case said earlier. It takes several days from the time I file in the True Filer system
Yeah.
until it's approved, and then there is a stamped copy. I just try to notify, and again, I understand what I emailed this morning, the amended motion and what
Sure.
I didn't previously call declaration, but it was a declaration, the one from May 15th, pertaining to what I'm specifically attacking here.
Right.
It takes several days between me filing in the electronic system. I always file first, email second. But if I waited for a stamped copy, that would delay both working copies for Ms. Peterson and the Family Law Department, I believe that's what they're officially called, as well as copies for Mr. Case. Again, excuse my sarcasm here, sir. I don't work for the state of Washington. I don't lie. Veracity or authenticity of these documents can be checked, and I'm just doing my best to do it quickly. I always file first, email next, but I don't want to wait for 5 days so that there is, blue letters on the side of the document. I will never file fraudulently anything. It's all stays in the True Filer system. And I know there's maybe because, I would do amended versions and so forth, but it's all on the record, what I have filed. And the problem of how Mr. Case and the state are served could be easily resolved if this court asks Mr. Case to accept electronic service. So this is the problem created by the state, not by a pro se with health issues and other limitations.
Understood. Thank you. Anything else then before we go off the record?
No, Your Honor, I would think that once he has his standby, he will be able to appropriately file and serve documents. That should solve that problem.
You guys quit throwing rocks at each other. Okay. So here's the other thing. This is very important. I'm going to strike the hearings that were set for today. Once you have counsel and discuss with counsel the matters, then they'll have to be renoted. Okay, I want to make sure that that's understood.
Your Honor, I'm
Go ahead.
asking, why can't we address
Mhm.
the
That particular issue?
Olympia,
November
November 2018?
issue. The reason that we can't is that all three of those orders, while they were individually entered, they all ended up, and including the child support, daycare, ended up as part of the child support amount. Okay. What that means then is that all of those things, while they are individual, relate to each other. And they all relate to the issues of contempt. It very well may be that the collateral attack on the daycare, if successful, will have the impact of removing that amount. That's very possible. But it doesn't make sense for us to bifurcate those, since we know that you're going to have at least some assistance from counsel as standby counsel. The fact that you asked that question is exactly why standby counsel would be a good idea.
Okay,
To be able to give you that information.
But I'm comfortable addressing limited scope of just this.
Yes, I'm not, though. I'm not comfortable addressing it in and of itself. I think it makes more sense, and it certainly is more judicious to be able to do it all at one time.
And Your Honor, if I may, the state's not comfortable with not having a date set. We'd like to set an order of continuance out, say 2 months.
You said that, didn't you?
And I was going to do that anyway. I just came from Seminole.
Sure.
So,
Sure.
yeah.
All right. Well, let's set, you want to set it 30 days out, and we'll see where we're at.
Oh yeah, there's June. No, July though.
Would that be? Oh, yeah, that's right. There's no.
July 10th.
Somebody's got to update our
July
calendar.
10th, I believe is one of our dates.
Monday after 4th.
Hang on, Ms. Tosic, we're coming up with a date here.
Or July.
And July 12th, it would be July 10th, sorry.
July 10th?
Your Honor,
July
may we
10th?
have it a little later, because the continued, but I believe the date is now final,
It's fine.
hearing at the state Supreme Court is on July
Go
11th.
another month, Your Honor.
Okay. Do you want to go 30 days after that then? August 2028 or?
Well, I'm not sure if I'm in the country at that time, because I intend to have summer vacation in the late July and August. I do not know exactly when, because ex-wife is basically
Okay.
refusing to get passport for the child. So this is the abuse.
Okay.
But the state sides with the abusive parent against the abused parent, which is exactly what's happening here for the past several years.
All right. Where do you get to go?
Overseas, if I can.
Oh, good. Well, I'm just curious. Where.
And again, I'm going to be back. I'm hoping to have a teaching job, part-time teaching job in September. It's not done deal yet. I'm working on all these things. And I'm dealing with obstruction of ex-wife insofar as my rights to visit my family with my daughter. I mean, this is outrageous.
Can we get to a date?
Violating mine and my daughter's human rights, basic civil rights and human rights.
All right. Give us a date you want to go to.
It's very, just for the scope of what was to be today, probably the first Monday, I'm assuming it's going to be in front of you, sir. The first Monday after July 11th would probably be the best. I'll still need the time for discovering all these things, assuming the case stays with this court. But insofar as matters for my motions and amended motion from this morning, and matters that Mr. Case brought up, not the actual contempt, but these things that need to be clarified by then.
So the first Monday after July 11th? What's the first Monday after July?
It's July 17th. Your Honor.
July 17th?
That should work, yes, sir.
Very good. We'll send out notice.
So may I sign off Mr. Tosic as present by Zoom?
Can we mark off that July 17th is the date? And we'll send you a notice of that?
Who's being asked, sir? I'm sorry.
Oh, I'm sorry, Mr. Tosic. Yes. you.
Okay, yes. And sending electronically is fine. If the court is obligated to send via snail mail, that's fine. But as I told Mr. Case, electronic is fine with me.
You will receive that in the mail, Your Honor. All scheduling orders go out in the mail.
Okay, very good. We can go off the record now. Thank you, Mr. Tosic, for being here.
Thank you. The one last thing I want to mention, again, just to have it on the record before I turn it off.
Oh, hang on. We're off the record. We got to go back on the record. Hang on.
Okay.
You should know better than that. Okay, go ahead.
I do apologize, but what I always say at the beginning, today's hearing was per my motions. However, the entire matter is a form of intimidation and political persecution by the state, and this is my special appearance, not general appearance. And again, I'm not referring to today, I'm referring to the past 5 months and the upcoming months. These matters do belong to the federal court, even if I'm wrong on jurisdiction because of the pecuniary conflict of interest of the state, including, unfortunately, the way things are intertwined. The judiciary and executive branches both having conflict of interest when it comes to so-called child support. And that's been a problem. That's why there is so much corruption in this state and other states that abuse Title 40 similarly. And again, it's my special appearance, and I'm not here specifically. I'm not dealing with the state of Washington out of my own volition. Since the state is going after me, I'll go after the state. Thank you, sir.
Okay, all right. Thank you very much. I appreciate that. All right, and we will see you then on July 17th. All right. Now we've lost reference.